I have a question on this. I used to argue with Denise Siegel all the time on this one. I would use property record cards if I was doing a house for the comps, because I can't trespass and measure somebody's property. I can measure the subject, but I would tell Denise is, I want to use the property record card for the subject, because at least it's being measured the same way that the comps are. If I can't measure the comps, and I measure the subject, now it's maybe apples to apples, and I know I can get different answers if you use a walk wheel, if you use a tape. So do you think it would be better to rely on the same source for everything if you can't measure the comps? Use the property card for both, or should you go with the square footage of the subject that you can measure?
Yeah, in that instance, and I know it's difficult to get into the comps. I understand that. But I would use the correct data that you have for the subject. If you have a number for the subject that's different than the property record card, you can use that. You may have to, you look at the property record card for your comps, you may then have to go to other sources. If the property was on MLS, see what square footage they used. That may be the same square footage that's on the property record card. It may be different. But you've got to look at that. If there are any other appraisals on those properties, when they sold, talk to people. Maybe knock on the door.
Well, I just need to say to the camera, in case Denise ever sees this video, that she was right. I eat humble pie.
What I generally look at is if you talk to an assessor, you talk to someone who's got, you look at public information. There's always in the local newspapers sometimes, there's the list of real estate transactions that happened within the last month. There are some websites that collect sales data, and you can purchase that data from the website. That is not verification. That really is raw data. All that is telling you is that a transaction occurred. You need to take those next steps to find out what really occurred in that transaction. What was the motivation of the buyer and the seller? Was there anything else included? Was there financing? Was there seller take-back financing that was going on? Was there below market rate financing from a bank? Were they buying leases, an income-producing property, fully tenanted? And you want to use that sale. Did you look at the leases and the income stream? If those leases were entered into 15 years ago, and a rental stream is going to be ending in another 4, 5, 6 months, and you looked at the income and it doesn't support the sales price because the purchaser is saying, I know within a short period of time I can get new tenants in at market rate. Conversely, if the property was leased at the height of the market and you've got very high leases, the town's going to want to use those, but you can show by looking at other market transactions contemporaneous to your valuation date that those leases don't represent market leases today. And you can come down, but you really have to look at them. You have to go more than just talking to one individual.
Yes, I want to. In our area in Oklahoma, most of the realtors utilize the assessor records for the square footage. If they utilize something different than that, and they put in there that it was stated from the owner, we will call them and say, "Did you have a copy of, this square footage that the owner provided you? Do you have a sketch or something where an appraiser measured it?" And they said, "Well, no." And we're going, "So how did you get that amount?" "Well, that's what the owner told us it was." So to me, it's much better to go with what the assessor says than what the MLS says based on what the owner told us that didn't have any backup.
Could very well be. With that explanation, that the only information that you could possibly get was the property record card, that the discrepancy between the MLS and the property record card was owner provided, and the owner didn't provide the architectural plans.
See, you're not going to know they didn't provide it unless you call the realtor and ask them.
You got it.
So there again, you can't just, go by that. You're going to have to make that phone call. I think I'm
One real quick comment before Laura asks her question. One of the things that I found, at least sort of the real world, if you rely on the property record card, it's very unlikely that the assessor or the town's going to disagree with you, and you won't get asked those questions.
I had a situation that in a town in Ocean County for a tax appeal, and the assessor took it upon himself to deem it non-usable because it was a relocation. And my view of relocation is when a relocation company owns the home and then sells it. She took it upon herself to think because they sold it and moved that it's a relocation. Well, for that matter, everything's a relocation. Well, how do you perceive it? Am I wrong in how I looked at it, or is a gray area?
I don't think it's a gray area. I think it's an area. I don't look at the NUs. If someone tells me that was an NU sale, I don't take that. I want to hear what the appraiser did to determine that that was a market transaction. And if you talk to the new owner,
I spoke to all the realtors,
Yeah.
because she used at NU 26, like it was going out of style. And I called all the, both realtors on the transactions, and only because I put phone calls out, whoever called me back, last time both of them called me back, and they were gonna back it up with letters, which was nice for me and surprising. But when I spoke to the assessor, she's telling me, well, they moved out of state. Well, you're allowed, you know? And I just found it, misleading, how she interpreted a relocation. Wouldn't you say if a relocation company owns it, that is the true relocation sale, and maybe you shouldn't use it because of other circumstances?
I wouldn't get into the relocation issue. To me, it doesn't matter if you move across the street or if you move around the world. It's what was the bona fides of that transaction. What happened within that transaction. And I don't, what I mean by that, I don't take the NUs. I just don't accept the assessor's word that was an NU sale. Just as if I don't take the assessor's word on it was a good sale. Didn't kick it out.
It goes back to what we said in the beginning. If it meets the definition of market value, was it exposed to the market? Was it had a broker? Was it arm's length? Was it? And the other thing is that as far as the assessor is concerned, they might not settle with you because of their opinion. But if you go to an appeal, they're not the judge.
Well, the funny part was when she gave the sales that she used, I researched them, and hers was a relocation sale. And I called her, and she said, well, I don't have to defend what I obviously did. And I said, but you're using a legitimate relocation sale, and you're telling me I can't because you heard that this person sold because he wanted to move to another state. How's that fair?
No offense to the assessor. The assessor shouldn't be directing you as to what's acceptable and not acceptable. You do your market research. If that sale comes up, you can use it.
How that worked out.
Just I wanted to add, the problem with that sale, the relocation sale, is you don't know the terms of the relocation appraisal because they put constraints on market time. And you make adjustments for that in the report based on they want to sell the house within 90 days or 120 days, and the real market time for that house might be 180 days. So that's the only reason I could see not using that sale.
Which may fall into the definition of willing buyer, willing seller under no
Right.
compunction.
Right.
Properly exposed to the market.
Judge, this question is towards you. A lot of attention has been given to the Greenblatt versus Englewood matter. It is a published opinion. A lot of attorneys have read it. I have a twofold question. Number one, since the appraiser didn't exactly justify or cite his sources, what could he have or should he have done to better justify his sources, basically what you use, the wheres and whys? And number two, if that's going to be the norm, what would some of the more reliable sources and justifications for the adjustments, for example, a bathroom, would it be, obviously paired sales would be the best extraction, but probably very difficult to do. What would be a better source of, a source to adjust, to make the adjustment, for example, a bathroom, keeping it simple?
Sources that I would accept, and as I said earlier, it's only me, I would accept if you spoke to plumbers, contractors in your area, what the cost to put a bathroom on. If you use a cost manual, the assessor's manual, the RS Means, Marshall Swift, or any other recognizable cost manual, to say that's how I developed the cost for that. That gives me some data. It gives me information that I can then look into and delve into, and it allows the other side to cross-examine you.
Okay, now, based on the plumber saying it costs, making these numbers up, $10,000 to make a bathroom, it's what will the buyer pay for that bathroom? It's, will the buyer pay $5,000 for that bathroom?
Well,
or
with that,
20?
you're also going to have, most likely, sales of homes that have the number of bathrooms that you have, sales of homes that don't have the number of bathrooms that you have, and you're going to make a correlation between the cost and the sales, assuming that all other things are comparable within those sales.
Right,
Or
but
you make
that
appropriate
doesn't always work either. You could have two
Yeah, no.
identical houses, and one will sell for 200,000, and one will sell for 150. A bathroom is not going to be worth $50,000.
Understood, but all I can tell you is what I would look at is for sufficient data so that the appraisal gets put into evidence. I can't tell you how I'm going to measure that and weigh that evidence unless and until I hear the other side.
Yeah, if I may, just one comment. We talked about comparable sales and how important they are to verify them and to know your comparable sales and know your neighborhood. I think the one thing that we missed was know your judge.
Yes?
No, and I mean that. I think everyone has their own, some have their own idiosyncrasies, so it might be good to read up some of the decisions that are published for the judge you're going to be appearing in front of. I think, Chuck, you'll remember a number of years ago there was a judge that on all income-producing properties was a 50% expense ratio, 10% cap rate. So he really didn't need us. So you really should know your judge as well as you know your neighborhood and your subject properties.